Hello, and thank you for joining us for podcast number 3 of Covering Your Assets in Divorce. I'm Jane McAuliffe, certified divorce financial analyst with Collaborative Divorce Strategies, a local Rhode Island-based divorce financial planning firm which works with individuals and couples to help mediate and negotiate the financial settlement in your divorce. And I'd like to take a minute to tell you how I arrived here. I went through my own divorce about 4 years ago and have been in the financial services industry since 1998. And for a short period of time before I got divorced, I jumped out of the workforce to care for my 2 small kids. And at the time of my divorce, I realized that, you know, after being struck with complete fear and panic about how I was going to financially support myself post-divorce, I realized that there was a lot of intricacies and a need for planning throughout the process to make sure that post-divorce, long after I'd signed off on the dotted line, that I was going to be okay. I think that's the number one question that people have when they realize that they're going to get a divorce is, am I going to be okay? And the reality is that you will never know the answer to that unless you've actually done some planning around it. You need to know what your income's going to be, what your potential support will be, how to divide your assets, what you can and can't negotiate for. So it's ultimately how I ended up at this position and why I am so passionate about this line of work and how I just truly enjoy helping people throughout this process to witness their transformations from being unengaged or disengaged to become completely in control of their financial future after the end. So today on this podcast, we're going to be talking about defining and making a case for your support. I have a very special guest with me today. His name is Timothy M. Sweet of the law offices of Timothy M. Sweet. Welcome, Tim.
Hello. Thank you so much for having me on your podcast. You're doing a great job.
Thank you. So as you know, I love having legal expertise on my podcasts because it really helps define what the courts will look at as we move through the process. So from a financial advising standpoint, I work with clients to help nail down what their current budgetary needs are, which is a very important part of the initial part of the process of filling out all the documents. But not only that, we take a forward-looking view of how this support will affect them in the short term and in the long term. And in the state of Rhode Island, we'll be talking about some of the guidelines here of child support and alimony, some of the different taxable consequences of each. And I'd like to talk and get Tim's expertise on his experiences with clients and how to best make the case for both child support and alimony. So let's break it down in 2 different parts. I'd like to take child support first and what the definition of that is. So as you know, child support is support from usually the non-custodial parent to the other parent to support the children's expenses, such as basic necessities like food, clothing, and shelter. But I bet you didn't know that there are also ways to negotiate that child support agreement for other things, such as medical care, uninsured medical expenses, educational fees, child care, and maybe perhaps transportation and travel. Tim, have you had any clients that you've negotiated a higher child support guideline for?
Sure. And what it comes down to in child support is that just the way that the algorithms are calculated and drawn up is that they're, in every single case, invariably, the custodial parent, let's say the mom, to keep it simple, the mom who has the child, Monday through Friday and has to worry about them and tend for them, and then will always feel as though she is not getting enough child support, and then the non-custodial parent will say the dad who has the child, say, on weekends, will without fail think that he is paying too much child support. And so, like so many things in the family court, you have 2 people who both feel unhappy and both feel underappreciated and overwhelmed because the child support figures are such that mom or the custodial parent always feels like she's getting too little, and dad thinks that he's paying too much, and the best interest of the child is mixed in somewhere in the middle.
It's so true. And I mean, I can refer back to one specific case where this might have been a bigger issue. The husband lived in a different state and had health care coverage through his work employer in the state of New York. The wife subsequently lived here with the 2 children in Rhode Island. And both kids had special needs, and she was attending a lot of therapy sessions with them to help them with whatever special needs that they had. And what we found was their out-of-pocket expense every single year for their therapy was in excess of $16,000 and was almost as high as $20,000 one year. With some careful financial planning, we were able to look at her possibly getting some additional child support to help fund a policy locally through Blue Cross Blue Shield, which would help effectively lower her out-of-pocket expenses, actually both of their out-of-pocket expenses, because Dad was going to be expected to contribute to these expenses even post-divorce. But we were able to effectively negotiate if he cut down his family plan at work and gave to an individual plan and then gave that difference to wife as part of a child support payment, she would effectively obtain new coverage here where the boys would be much covered. We'd have a much lower out-of-pocket expense for both parties involved, and the boys would ultimately get better care as well. So that's something that I work alongside on the client level with, and then also with the attorney's input. This is something that you can take back to the judge, I'm sure, and to the opposing counsel, Tim, to help make that case for your client's support, increased support.
Well, that's so interesting. Now, did it take Dad a long time to figure out that was actually in his best interest, that he might be saving money that way and be in the best interest of his children?
It was funny because this was brought up towards the end of the process. This couple had been trying to get divorced for quite some time. Their case had been going on for a little over a year and a half, and I got pulled in towards the end because obviously when we did the budgeting for wife's expenses, she was also a candidate for spousal support. So when looking at the wife's expenses, I mean, they were exorbitant. They were in excess of $100,000 a year. Now, there's also a finite amount of income for husband. So, to make a case for her to obtain child support and spousal support to cover her budget was unrealistic. She's also a stay-at-home mom currently. So we worked really in depth. Actually, they were about to go to trial. So we spent a few days in chambers with both attorneys, or I spent the day with both attorneys, and we really hammered out, and I showed them both the numbers on why this made sense. And we went to the husband's attorney and to the husband. I ended up having a lot of interaction with the husband and talking about why this is best for him, because he's not on the hook for these out-of-pocket expenses down the line, but it also gives the boys access to the therapies that they need now. And also, it worked out where his coverage was not accepted widely in Rhode Island. So this was a different case, but one that ultimately had a lot of financial benefits in the end.
It's funny that you say that the wife had an exorbitant amount of expenses at over $100,000 a year. I wish you'd explain that to my wife, that is in fact exorbitant and not normal. Now, so you came in and saved the day then, not only for the judge or for the lawyers, but for those kids, because you with that tangential thinking, with your creative problem solving, you came in, and I'm assuming they skipped trial.
They did. They avoided trial, which avoided a lot of financial and emotional resources, as you know.
Right.
I think the judge was starting to say, enough's enough. We got to figure this out. And I did. I wasn't brought in early enough in the process, I think.
Is that common for you?
It is common.
You're brought in to save the day at the end instead of at the beginning.
Yeah, and that's why it's so important. And my message here ultimately is to get ahead of these things well in advance, because you could get divorced a lot sooner. Save your and your spouse a lot of headache and time with court appearances and attorneys. And in this case, the husband was traveling from New York for all those years. And, it was just they were ultimately both thankful. Her attorney, his attorney, him and her were all very thankful.
And do you remember about how much husband made? What was $16,000 to $20,000 out of pocket? Was that going to affect him, or was he such that was just water off a duck's back for him?
They had a big financial problem. They were also looking at splitting quite a bit of debt because they had slid into this scenario where they'd been spending above their means for many years to take care of the boys. So we're cleaning that up on the back end as well for wife. So There's a lot of benefits that have come out of that.
A work in progress.
Yeah.
But imagine if she hadn't found you, where she and those boys would be now.
I know. And her attorney had brought me in, which I was very thankful. I think he was just saying we've got to rein in the expectations. We were able to effectively negotiate an alimony settlement for her in addition to this. That's going to last a few years so she can get educated and matriculate back into the workforce. So another note on child support in the state of Rhode Island and Mass, they just recalculated the guidelines as of September 1st, 2017. So if you're currently in negotiations for a divorce, these are going to be different if you're not fully divorced yet. Another difference between child support and alimony is that child support to the receiver is not taxable. So, but that also means the payer, whatever that person is paying in child support, cannot deduct that from their annual taxes. So there's a big difference between that and spousal support.
And please, if you're not driving while you listen to this, write that down, because I cannot underscore the importance of that the tax consequence and the differential between child support and alimony.
We talked earlier in another podcast about basing support on income, especially if you have a business owner who has a variable amount of income every year, right? Or maybe you're a salesperson and you have a base salary of $75,000, yet you make one bonus per year, and perhaps that's $250,000 bonus. How do you base support on that? How do you effectively get what the payee spouse is obligated to help with their monthly needs? How do you craft a settlement like that? So that's where I come in with the creative thinking and settlement strategies for someone like Tim, who's advocating on the legal side of things. How do we figure that out? How does that best work for the receiving spouse?
I have a trial on that tomorrow. There's another case where Jane wasn't brought in time.
Next time. All right, so let's move on to alimony, also known as spousal support. So spousal support and alimony is so unlike child support, which have guidelines attached to them in all the states, courts have much broader discretion as to the amount and length to award for the spouse. So typically, obviously, I work with the out spouse 9 times out of 10. And what that means is the spouse has not been involved in the day-to-day finances or doesn't have a complete picture of what their financial marital estate looks like. Or perhaps they've been a stay-at-home mom for years and they've taken time out to raise the family, and now they're facing re-entering the workforce to supplement their income. And they're, quite frankly, scared and terrified of what that could mean for them. So they do need some sort of temporary support. Again, this is based on a couple different things. It's based on, number one, the age, physical, conditional, and emotional estate of the former spouses, the length of the time recipient would need to become self-sufficient. And again, that's a huge unknown. It also looks at the couple's standard of living. Well, 9 times out of 10, I can honestly tell you that I see couples that are living well beyond their means on their income and just maintaining one household. So the prospect of maintaining 2 households on the same income is daunting, to say the least, and they wonder how they're going to afford to do that. The court also looks at the length of the marriage, the ability of the payor spouse to support themselves after potentially paying spousal support and or child support. All of these factors come into play, and I can tell you that you can negotiate. This is where the negotiating comes in huge, and having numbers to back it up is so important, where you can go to your attorney and go to the judge and say, this is what my budget looks like. I'm making choices. I'm downsizing. I'm moving. These are my assets, but this is what I need for the next 3 to 5 months until I can get back up on my feet. This helps your attorney tremendously in making the case for the length and the amount of that alimony payment.
It does, which will also be determined first and foremost by what judge you get and the roulette of your filing, as with so many other things in the family court. And alimony is largely discretionary, and believe it or not, it will be the last thing you decide, because the judge will not sit there and listen to you or to your attorney discuss alimony until the judge knows what your asset portfolio looks like from the divorce. And that makes sense, right? Because if a husband is there asking for alimony and it turns out at the end of the divorce that husband is going to receive $425,000 from his wife's 401k, and that the marital home is paid off, and that he's in good health, and that's not an argument that's going to carry a lot of weight. It's not a dog that's going to hunt. So judges, first of all, they want to know, they want all the other pieces to fall in and for the dust to settle on that before they're going to have the alimony discussion, because if you have $425,000 in assets or even in liquid cash, then I think most judges will say, I think you can live off that until you figure out what you're going to do in your next phase of life. So alimony is always the last thing decided, which is, now that I think about it, Jane, is probably also why you're brought in at the end, because the alimony is kind of the little hobgoblin in the corner of these divorces, and they don't deal with it until they absolutely have to.
It is, and a large part of the planning that comes into play with this is alimony, unlike child support, is taxable to the receiver, and it's tax deductible by the payer. So if there isn't enough cash flow to support a future alimony payment after all is said and done, we also can look at creative ways on asking for an additional piece of the marital estate, or in other words, additional assets in lieu of alimony, which will be considered part of the property settlement agreement. So what that means is, instead of receiving $3,000 a month for the next 3 years, the husband says, I can't afford to pay that. Okay, well, let's look at getting wife an additional 5 to 10% of the marital assets. What does that look like from an after-tax standpoint, and how does that affect each one of them going forward? In a case that comes to mind, actually, I'm working with an older couple. They're actually in their 70s after 48 years of marriage, which is very unfortunate. But we're looking at trading the house in lieu of retirement assets. And she's asking for alimony. Obviously, 70-year-old, he's got a limited time frame for working. In her case, we are doing some planning and making a case for getting an additional part or percentage of the marital estate to support her as a lump sum. Two benefits to that. She knows exactly what she's getting out of the settlement, and she can then make her financial plan according to that. Secondly, it allows them to not have any future contact with one another. So you're not chasing an ex-spouse.
Yeah. Amen. And it's much, much easier if you understand the after-tax consequences to say, if one spouse, say the payor spouse of the alimony, is a small business owner, and you can go to him or her and say, look, you're going to pay $3,000 a month for 3 years in alimony, but that's $3,000 per month less than you're going to have to pay to the federal government, or you get a tax write-off for it, and it's going to help in your tax picture come springtime. And no matter how bitter the divorce, I think if you're talking to, say, again, to use the example, if you're talking to a wife who's going to pay alimony to a husband, and the kids are living with the husband, and it's a lot easier to say to the wife, yeah, you're going to pay him alimony, but that $3,000 a month is going to go to further support those children, because it's going to make life easier on the husband. And there's never so bitter a divorce where the spouse wouldn't rather have the parent of the children have that excess money than the federal government.
Some other last points to consider as we talk about support. I can't stand the term, but Rhode Island uses the term of rehabilitative alimony. Ugh. Anyway, it just means it's the ability to allow that spouse to rehabilitate themselves, to get back up to speed, to get back into the workforce. So you may hear that term floated around a little bit. Also, Tim, I'd love to hear your thoughts on how the courts use imputed income and what that means.
First, why don't you like the term? We don't like the term rehabilitative. Why not?
It's so degrading.
Interesting. Imputed income in what context?
So have you ever had a case, I have a couple right now, where the mom has been a stay-at-home mom for a number of years, or maybe they've had a part-time job and they're underemployed, but yet they were a lawyer in their previous career. And yes, they could return to the workforce. This happened in my own personal case where I didn't even know what my alimony was until the day that I got divorced, but the judge had said we are imputing an income to her to base support on. So in other words, using the guidelines for child support or alimony, we're going to assume that Jane is going to re-enter the workforce making $75,000 because A, she's educated, she has a career where she could matriculate back in and has all these, degrees or credits that she's not going back to look at a $10 an hour job. So we're going to impute income to her for the purposes of support.
That's a dangerous game, isn't it?
Yeah. That's
a very dangerous game. Unless the parties can really afford to while away their afternoons with an expert on the stand telling me what he or she could make in the current market, I think that's a very dangerous game. But like with all things, the family court, although it tries its best, can be a bit of a blunt instrument when making these decisions.
I'm sure we could fill a whole nother series of podcasts talking about these topics, which we probably will.
We probably will.
On some of the intricacies and some of the pitfalls and obstacles that you may reach with this. But a few takeaways. Determine the income available for support, as well as what your needs are in making your case with your lawyer and with your judge. That's where someone like myself, a certified divorce financial analyst, can help you. Secondly, planning early can help avoid making poor financial decisions at the time of the settlement. You will know exactly what kind of support you need in order to fund your lifestyle post-divorce. That's huge. Third, knowing what your income is and what it will be will happen when support ends, and determining if there's a gap in that budget, and then potentially what assets you may get from the divorce and how you can access that is a huge part of the planning piece. And again, that's where I can help you. Thank you for joining us today. I'm Jane McAuliffe, CDFA at collaborativedivorcestrategies.com. You can find me on Facebook and LinkedIn at Jane McAuliffe, or at my website, collaborativedivorcestrategies.com. Tim, why don't you tell people where they can find you?
I can also be found on Facebook, Timothy M. Sweet. My office is in Providence, Sweet Family Law, 10 Elm Grove Ave, one word, ELMGROVE, Providence, Rhode Island. You can find my website, www.timothymsweetlaw.com, and email me timothymsweet@gmail.com.
Thanks again. I'm Jane McAuliffe at collaborativedivorcestrategies.com. Stay tuned for our next podcast series covering a number of other different topics, such as dividing your retirement accounts, post-divorce considerations, and crafting a settlement that won't land you back in court. See you soon.